Welcome to the second session of the ARPA Benefits Compliance Updates and FAQ webinar series. Thank you all for joining us. Our Benefits Compliance team will be moderating today's call, led by Beth Allen. At the end of the call, please post your questions in the Q&A as opposed to the chat. We'll try to get to as many of the Q&As as we can in the time allotted after the main discussion. As you may have seen in our communication from last week, we will be extending today's and next week's sessions to 1.5 hours to ensure that we cover all of the material. If you are unable to stay on the call for the duration of today's call, today's presentation is being recorded and will be emailed tomorrow. The recording and slide deck from this webinar will be posted to nfp.com latest insights page under webinars/training. At this time, I would like to introduce our speakers for today's webinar. Joining us today are Diane Cross, Vice President and Counsel, and Carol Wood, Vice President and Counsel from the Benefits Compliance Department for NFP. We are very excited to have them speaking with us today, and it is my great pleasure to hand the call over to our speakers. Carol, the floor is yours.
Thank you, Leanne, and good afternoon, everybody. Thank you for joining us. We're happy to be here with you to review ARPA, the knowledge that we have, and some guidance that we just received today, hot off the press. We know you have a lot of questions, and we have a lot to cover. So we'll get started. Just moving to the next slide with our first our disclaimer. Of course, the following is intended to be used for general guidance purposes only. It's not intended as tax or legal advice. Any questions regarding the application of the law should be addressed by your own legal or tax counsel, and this information is current as of today. I just want to review with you our agenda, and there is some flexibility here because of the new guidance that just came down today from the Department of Labor, which we've tried to incorporate in the presentation. And we also would like to address some of your questions throughout. So we're going to be a little flexible. We may not cover all the topics at the end, but the general idea here is to have just a really quick overview of the bill, point out some of the new guidance, the frequently asked questions, and points that have been clarified by those. And we'll also review the model notices in the notices section on COBRA subsidies. The COBRA subsidies will cover, which is the main topic that will take up most of our presentation. We'll cover eligibility, elections, the interaction with the deadline extensions, notices, of course, and then briefly the tax credits. And then if time allows, we'd also like to touch on the provisions of ARPA relating to the FFCRA leave provisions, the new qualifying reasons, new non-discrimination requirements, notices and tax credits, and then also the DCAP exclusion provision under ARPA. And throughout, we're going to try to include employer action plans, really what should an employer do at this point in time, given the guidance that's available. Moving on just to a quick overview of the bill. It was signed into law, the American Rescue Plan Act of 2021 on March 11th. Hot off the press, just this morning we received guidance from the Department of Labor in the form of frequently asked questions and also the model COBRA notices. We know employers have been waiting for those, so they're available on the DOL website, and I'm sure you'll want to check those out, and particularly the notices, just to review those. This is really information that we've been waiting for. ARPA, of course, was largely designed to provide COVID-19 relief, and it includes benefit-related provisions, amongst others. The ones we'll focus on today are the COBRA subsidies, optional FFCRA extension, and the increase in the DCAP exclusion. We're not really going to spend time focusing on the premium tax credits or the provisions affecting the defined benefit pension plan. Just wanted to, you did a quick summary of the frequently asked questions, and the points that they clarified, and I think these are significant. So we'll go through these, but they're also incorporated in the presentation, so we'll try to talk about those when we can. We've tried to adjust our presentation to accommodate this new information. So starting out, the first point here is that the term involuntary does not apply to reduction of hours. We know that those individuals who are eligible for the premium subsidy are those who were involuntarily terminated or experienced a reduction of hours, and it was unclear whether the involuntary term applied to the reduction of hours as well as the termination. And from the guidance that we received today, it seems that it does not. There could be a reduction of hours for other reasons, maybe a temporary leave of absence and a medical leave or something where an individual is not terminated, but there's a reduction in hours and it's not necessarily involuntary. So that was the first point of clarification from the DOL frequently asked questions. The second, the questions indicated that an individual is not eligible for a subsidy if they're eligible for group health coverage through a spouse's plan. Keep in mind that was another requirement to be a subsidy eligible and assistance eligible individual, as it's called. You could not be eligible for coverage under another group health plan or through Medicare. And the question that was frequently asked is, well, what if the individual themselves aren't eligible for an employer's group health plan coverage, or maybe somebody was terminated, but they're eligible through a spouse's plan? So that, the DOL has confirmed, would render that individual ineligible for the subsidy. Next, an individual is not eligible for special enrollment unless the original COBRA qualifying event was a reduction in hours or an involuntary termination. There was some question because of the statutory language, which is really all we've had to go by at this point, as to whether individuals other than those who had experienced an involuntary termination or reduction in hours would be eligible for a special enrollment, even if they were not eligible for the subsidy. And this guidance seems to confirm that no, that's not the case. Those eligible for the special enrollment are those who experience either the reduction in hours or an involuntary termination. Next, the guidance confirms that the regular rules on email distribution apply, meaning the Department of Labor rules, electronic distribution rules. And we know that typically with COBRA, electronic distribution is not a great option because the individuals are terminated, they don't have access to email, computer access at work, as some individuals who experience a reduction in hours might, and typically they haven't provided any type of consent and to have the information sent to a personal email. So normally the information would be mailed to these COBRA beneficiaries as they're no longer at work and have integral access to the employer's email system. Next, those eligible for the subsidy would include those who are on Medicare, or eligible for a Medicare or a marketplace plan. So that would not exclude them from receiving the COBRA subsidy. However, if they do enroll in the COBRA, then they won't be eligible for a premium tax credit. So that's another consideration. Individuals can enroll in coverage on the exchange after the subsidy ends. I know we've received this question, so that was clarified. Individuals can choose to start their coverage as of April 1st, even if they have not received an election notice. And I think we were aware of this, that for those who are eligible for the special election, The notice, they were not required to receive a notice until the end of May, but the coverage would be retroactive to April 1st. So the frequently asked questions confirm that. And then finally, assistance eligible individuals have 60 days to elect COBRA after receiving the notice, or they forfeit their right to elect COBRA subsidies. So, this is confirming what's really the normal COBRA election timeframe. I think there were some questions here as to whether that would apply because of the deadline extensions that have applied to COBRA. That confused things a bit, and we'll cover it later in the presentation. I think it still confuses things a bit. There's still a lack of clarity here as to how the two interact, but it is clear, though, that the individuals will only have 60 days to elect COBRA and receive the subsidies after receiving the notice. And that's our summary. And then we'll go into the presentation that we had prepared, where we've tried to note where one of the frequently asked questions addressed that were released today, addresses the particular issue as well.
Carol, one thing I'll mention just briefly to everyone is we did get a request for the links to the bill that y'all had on that first overview page. So if you look in the chat, I did put links to both the bill, the FAQs, and the model notices.
Okay, great. Thank you. Okay, an overview. What COBRA subsidies are provided by ARPA? ARPA provides a premium subsidy for qualified beneficiaries who elect COBRA. The subsidy covers the entire cost of the COBRA premiums. Previous versions of the bill proposed 85%, but the final bill was 100% of the cost of those premiums. And it applies to COBRA premiums for coverage periods between April 1st and September 30th of 2021, or until that individual becomes eligible for other group medical or Medicare coverage, whichever comes first. Is this optional for employers? And the answer here is no. This is unlike the FSCRIV provisions. This is a mandatory provision, so it really has widespread application. Our state continuation programs also consider COBRA coverage for this purpose, and the answer is yes. So even though it's not subject to federal COBRA, would be subject to this requirement. Which plans are subject to these rules? ARPA applies to all group health plans, fully insured and self-insured, providing major medical benefits that are subject to federal. By federal, I mean ERISA, the code, or the Public Health Service Act, PHSA, or state continuation coverage requirements. This would include your major medical, dental, and vision. We believe it would include HRAs as well. Health FSAs are accepted from these requirements. And then the questions that we receive here are state and local government plans subject to these rules. And the answer here is yes, because they would be subject not only to the Public Health Service Act requirements, so they would be subject to these requirements as well. What about church plans? The answer here is generally no. We know that church plans are not normally subject to ERISA. It's possible that they could elect for ERISA to apply, although that's pretty unusual, or they may be subject to some type of state continuation requirements, but that would be the exception. So the answer to that would be generally no. Are EAPs and on-site clinics accepted? Whether the coverage provisions would apply here really is going to depend on whether, take for example, the EAP would be subject to coverage to begin with, which would generally be if it's providing significant benefits in the nature of medical care. So if it's an EAP that's really just a referral service and not much more, it wouldn't be subject to cover in the first place, and they wouldn't be concerned with these provisions applying. But once the EAP is providing more significant benefits and would be considered a group health plan subject to the requirements, then COBRA obligations could attach. And just to review here, who is eligible for the COBRA subsidy? To be eligible for the subsidy, the qualified beneficiary must have experienced an involuntary termination of employment other than for gross misconduct or a reduction of hours. It need not be COVID-19 related. They must not be eligible for other group health coverage or Medicare. And again, we're referring to eligibility here and not enrollment. Must be within their COBRA maximum coverage period for at least 1 month during the applicable time frame. And the subsidy period would be April 1st through September 30th of this year. Significantly, spouses and dependents have an independent election right to continue COBRA if the employee was terminated or had their hours reduced. You could even have a situation where the employee themselves may not be eligible. Maybe they're eligible for Medicare, but the spouse or dependent would be in that situation, and they would have an independent right to elect COBRA. We've been asked this question: what rises to the level of gross misconduct? It's not clearly defined by ERISA, and courts have come to different conclusions, but it's a high bar. It would be the most flagrant conduct. It's very rare that the termination would be considered for gross misconduct where COBRA rights would not apply. In fact, it's so unusual that if an employer is considering it, we would advise that they consult, with counsel, because if they make the determination that it's gross misconduct and it's determined otherwise, by a court, then there could be penalties of, $110 per day for failing to provide notice, et cetera. So it's a very high bar. It's not going to come into play very much. What should employers do if they did not maintain good records as to the cause of the termination? And that's really a situation to consult with counsel. There are implications to that, I think, beyond our ARPA COBRA subsidies, but it's definitely a concern. The employer is receiving the tax credit, so you can't just assume everybody was involuntarily terminated. You'd want to consult with counsel. I know there have been in requests for clarification to regulators. There have been that question has come up, some proposals, could we ask the employees to certify, the reason, but we really don't have guidance. We don't know if we're going to receive any, so that would be an issue for counsel to review. Does involuntary termination include former employees who voluntarily terminated employment for reasons related to COVID-19, let's say to care for an elderly family member? And I think even now, even with the new guidance, it remains unclear how involuntary termination of employment will be defined. In many cases, the determination depends on the particular facts and circumstances, but resigning to care for a family member is employee initiated. Typically, that would be considered voluntary as opposed to employer initiated action. Regulators, there has been some prior guidance going back to 2009 when COBRA subsidies, there are also COBRA subsidies as to the definition. We don't know if the regulators will choose to follow those prior definitions in that guidance, or maybe choose a different and more expansive definition against the COVID-19 backdrop. The questions that come up as far as involuntary terminations are, what if the employee retired or accepted a severance agreement? And you may, particularly with the first one, say, well, that's voluntary. But again, I think with facts and circumstances, if it's a situation where the employee thought, it was they would be terminated if they didn't accept that early retirement or severance package, then that would seem to lean more towards the involuntary. So these are very difficult to classify situations. Also, with an employee who is working under a contract of limited duration that ended, you may just see that as voluntary. They only signed up for a certain period. But if this prior guidance is followed, there is one question that kind of relates to this, saying, well, if the employer continued, if the employer extended the contract and the employee would continue working, under the same terms, then, the termination of it could be viewed as involuntary. So again, depends on the facts and circumstances. Very unclear there. So we're still hoping for further guidance in that area. But would acknowledge that even with that guidance, I think there's going to be a lot of gray areas. If the COBRA qualified beneficiary is a qualifying event, is the employee's death, is this involuntary? And no, for this purpose, based on the prior guidance, that would not be considered involuntary. What should employers do if they're not sure whether an employee was involuntarily terminated? If you can't classify it, like I said, hopefully we will receive some additional guidance, but if it can't be classified, consult with counsel. I think you also want to document your analysis that went into the process as a fiduciary for the plan. And you took the obligation to make the classification seriously. What was your rationale going into it? And of course, just make sure you're applying that rationale, that process in the same manner to all similarly situated individuals. Okay, so here's your employer actions for now. Hopefully, you've already started reviewing employment records to determine which employees may be eligible for the subsidy. It requires looking back at least 18 months to November of 2019, as these individuals would still be in the standard 18-month COBRA election period. As we said, to be potentially eligible, the employee must have involuntarily terminated or experienced a reduction in hours. Involuntary termination is not yet clearly defined for this purpose. And in the interim, you could consider reviewing the prior COBRA subsidy guidance. That was IRS Notice 2009-27. To be clear, the IRS may not adopt this previous definition, but you may want to just take a glance, at that, should they choose to do it. Consult with counsel regarding those difficult to determine situations. Document your analysis of the relevant facts and circumstances, and apply the terminations consistently. And the process, of course, does need to be coordinated with the COBRA vendor. You may have the COBRA vendor sending the notices, helping to prepare them even, and they may have the most current addresses, particularly for those already receiving COBRA, but would not necessarily know who is subsidy eligible. They wouldn't have those employment records. And with that, Diane, I'm going to turn this over to you now that we've discussed eligibility, to discuss the special elections and the election process for these subsidies.
Hey, thanks, Carol, and good afternoon, everybody. Thanks, as Carol so nicely providing the introduction. Thanks for joining us on this ride as we're dissecting information as we receive it on ARPA and how it impacts the industry. But as Carol provided regarding eligibility for the subsidies, let's take a step further and talk a little bit more about what the special COBRA election period is. And as you may know, ARPA provides an additional bite at the apple, if you will. So an additional COBRA election period for certain qualified beneficiaries. And this includes those who would qualify for the premium subsidy and are within their maximum coverage period, but initially declined COBRA, or who enrolled in COBRA but dropped before their maximum coverage period expired. And I want to reiterate what Carol already introduced regarding the guidance we received today. This is a little bit different or a lot different from our prior understanding from the information directly from the bill itself. So with the clarifying information regarding the DOL's FAQs, they do explain that the second bite of the apple only applies to those who are eligible for the COBRA premium subsidy and are within the 18 months or their maximum COBRA coverage period but declined, and who dropped COBRA coverage period before the maximum coverage period expired. But they would have to be those COBRA premium subsidy eligible individuals. So we already belabored who is eligible for the special election. And then also to reiterate, are those who experience qualifying events outside of involuntary termination or reduction of hours also eligible to enroll during this special election period? And the answer there is no. And this is, again, hot off the press, straight from the guidance that we're in the midst of dissecting. But it is pretty clear from what we've reviewed so far that it would only include those who are premium subsidy eligible, which would mean they would have had to have, the triggering event for COBRA would have to be involuntary termination or reduction of hours. All right, so another question that we're continuing to receive is, how long is the special COBRA election period? So this period starts on the date the qualified beneficiary is provided with the new COBRA election notice, and it lasts for 60 days. Take it a step further, and if an election is made within that 60 days, continuation coverage will be retroactive back to April 1. Okay, so let's look at some clarifying questions here. This naturally elicits confusion on or clarification on when the deadline for providing the special election notice is. And the bill provides that that needs to be provided within 60 days of April 1st, and that's May 31st. So to recap here, individuals should receive a new COBRA election notice by May 31st, and their election period lasts for 60 days. Should they elect COBRA coverage, their coverage will be retroactive back to April 1. All right, next question. Does the special COBRA election period extend the maximum COBRA coverage period? And that's a straightforward no. It is expressly stated that the new election period does not extend the maximum coverage period for any qualified beneficiary who elects COBRA coverage under these circumstances. So for some clarifying questions, and what we're receiving from employers is, well, what if the qualified beneficiary's maximum coverage period ends during the subsidy eligible period? So what if it ends after April 1st, but before September 30th? And in that instance, the individual would receive the subsidies through the end of their maximum coverage period. So if somebody's maximum coverage period ends June 30th, they would only receive the subsidy April 1 through June 30 and would no longer receive COBRA after their maximum COBRA coverage expires, because the special COBRA election period does not extend their maximum COBRA coverage period. Now here's a question we still don't have an answer on. So what if there is a secondary qualifying event? All right, so let's look, the example here is an employee's death. Another example could be a dependent aging off plan, perhaps. This is still unclear how it would impact subsidy eligibility. And to further explain what I'm even talking about, let's take a quick example in that using that June 30th time period. So if an individual's maximum COBRA coverage period is going to end on June 30th, the 18 months, because the triggering event was termination of employment, but they had a secondary qualifying event that extended their maximum COBRA coverage an additional 18 months, like the employee's death, if you will. We're not sure how that impacts subsidy eligibility. I would go out on a limb and say it's likely not subsidy eligible for the remaining July 1 to September 30th, but it is unclear without any further guidance. So let's look at an example for some practical application. And we have Jenna, whose employment was terminated by her employer on January 15th of 2020 and became eligible for COBRA on February 1st of 2020. And so like if you joined us last week, this is a similar example where we want to reiterate that oftentimes when termination happens, the eligibility for coverage terms generally at the end of the month, which would mean she became eligible for COBRA on February 1st. Now, Jenna never elected COBRA, as many people don't because it's expensive, and is now eligible for other group health and is not eligible for other group health plan coverage or Medicare. So with the guidance that we have, Jenna would be eligible for this special election to now have that second chance to enroll in COBRA and receive the subsidized premiums. But like we were just talking about, she would only receive that through July 31st because that is when her maximum COBRA coverage period would end based on it beginning February 1st, 2020. Now, she would not be entitled to continue COBRA after the subsidy ends because her original COBRA coverage period expired. And to reiterate what we just talked about regarding the secondary qualifying event, we're not quite sure how that would factor into the equation at this point. All right, so another question. If a qualified beneficiary elects COBRA during this special COBRA election period, is coverage retroactive back to the initial eligibility or the date that COBRA coverage was dropped? And again, the answer is very clear here, no. That's the perk, if you will, of this second chance or second bite of the apple, that an election during this new election period is prospective. Now, subsidized coverage is not retroactive back to initial eligibility or the date that COBRA coverage was dropped, but it is retroactive back to April 1st. So is subsidized continuation coverage retroactive back to April 1? And that would be a yes in the instance where somebody receives the notice by May 31st and they elect within the 60 days that their coverage would be retroactive back to April 1. Okay. Now, how do qualified beneficiaries receive the COBRA subsidy? So we received a little bit of clarifying guidance here from the DOL's FAQs and the model notices provided. So generally, our understanding is that if they're subsidy eligible and have elected COBRA, they would not be charged the premium for those applicable months within that April to September timeframe. And those subsidy eligible but not currently receiving COBRA, so those that have that second chance to enroll, would need to be notified of their special election rights. And we'll talk about notification a little later on in our presentation. But the employer needs to coordinate with any COBRA vendors that may be in the picture because they likely do not know which qualified beneficiaries are subsidy eligible. And the guidance that we received today from the FAQs and the language in the model notice seems to clarify a few things. First, the model notice language seems to provide a form that should be returned along with the election form for an individual to be requested to be treated as an assistance eligible individual. Okay, so again, we're in the midst of dissecting the language, but our understanding at our quick glance from this morning when it was released is that the model general notice includes language that along with the election form, a participant or a qualified beneficiary would also return a form that's titled request for treatment as an assistance eligible individual, so that they're aware that they are subsidy eligible. Now, there's also guidance in DOL's FAQs 7 and 8 that clarifies if an individual believes that they're eligible for the subsidy and they didn't receive notice from the employer, that they can also submit that request for treatment as an assistance eligible individual. Okay, so some clarifying questions. What if the qualified beneficiary currently on COBRA already paid for coverage? So we're still seeing this as a common question. And the quick answer there is that they should be due a refund. And it seems, it's presumed that who would provide the refund would be the party who is receiving the credit. We don't have any further clarifying guidance on that, but they would be due a refund. Who would provide the refund is not necessarily clear, but it seems that it would be the party who is receiving the credit. So in many instances, which we'll talk about here shortly, it would be the employer. And so who is responsible for notifying these qualifying beneficiaries of their special election rights? And that's the employer. While they might elicit a third-party administrator or COBRA administrator, the ultimate responsibility lies with the employer. All right, and that being said, before I kick it over to Carol, some more clarifying guidance that we received today from the DOL's FAQs does clarify that the deadline extension guidance does not apply to the 60-day notice or election periods related to this COBRA premium assistance under ARPA. So as a refresh, there was we have an extension of certain time frames that includes the time frame in which one has to elect COBRA. And those deadlines are applied on an individual basis and could still apply for some. And that's because these deadlines are extended by the tolling period beginning on the date the person was first eligible for relief and ending either 1 year from that relief or 60 days after the announcement of the end of the national emergency, whichever is first. So some folks might be in a period where they can still elect COBRA retroactive back to their COBRA qualifying event. And there was confusion on how this interplays with some guidance under ARPA. And DOL's FAQ number 5 expressly states that the deadline extension guidance does not apply, so there is no extension to the 60-day notice requirement or election period that is required to receive the premium assistance for COBRA. And before I kick it over to Carol, Beth, are there any questions you think we should discuss now?
Oh man, we've been getting quite a few questions, very good questions from everyone today. I think one that we've got a number of times is kind of how, as it pertains to eligibility, how do employers go about determining if the qualified beneficiaries are eligible for other coverage? I can speak to that. No, I don't know if you wanted me to speak to it. But what we've been telling you all in the box, because we've gotten this from a number of people, is basically the idea that these rules don't necessarily put the onus on the employers to know that someone doesn't have or isn't eligible for other coverage. The individuals actually kind of have to certify through the forms that they're going to complete that they're going to be eligible for the subsidy because they're not eligible for other coverage, okay? And not only does the form require the individual to say that, but it does impose penalties if you are found to be lying about that, right? And so it's one of those things where from the employer standpoint, they're going to kind of have to trust these individuals that they're not eligible for other coverage, but if the people are not eligible for other coverage, they really do need to say so.
Right. Thank you.
Yeah, I think one of the other questions that we keep seeing is kind of just making sure that we make it very clear, having to do with the reduction in hours and whether or not that reduction in hours has to be voluntary or involuntary as well. And so obviously with the reduction of hours, the idea that it has to be involuntary is clearly not the case, right? So really it's any reduction in hours would apply. And I will say that the FAQ that we received today, I think it was FAQ 3, actually even took it a step further to describe what a reduction of hours would be. And it would be like a move from full-time to part-time. Again, not necessarily one that the employer initiated. It could be leaves of absences that people took. And so I think that that really does kind of clear it up on that idea that, you know, the reduction in hours does not have to be involuntary. And so those are just some of the major questions that we got. One other question that I'll just put out there briefly, just so that you all can talk about COBRA generally, is we've gotten the question a couple times about whether or not someone who, let's say, was terminated, but did not have COBRA on, or not, excuse me, didn't have COBRA, didn't have medical coverage on the day before they were terminated, if those people would be due basically an offer of COBRA under this.
Oh, yeah, so that's a great question. Well, it's my understanding that those folks would not be a COBRA qualifying beneficiary because part of the definition of that is that you must be covered under group health plan coverage on the day prior to the triggering event. Now, that's not to say if they were covered in another group health plan, like dental or vision, that they wouldn't be eligible for a subsidy related to that coverage.
Good. And we did get that question from other people. And another variation of that question having to do with like dental and vision and medical was this idea like, okay, well, what if the day before the event, they actually had medical, dental, and vision, but then when they elected COBRA, they only elected dental and vision. And the question was like, could they come back and now elect medical? And the answer would be yes, right? Because they did have it the day before the event and they don't have to have selected it to be able to come back and get it now.
Yeah.
So,
yeah.
Those were good questions, definitely about eligibility. So I'll let y'all go on.
Thank you. And with that, Carol, I will hand it over to you.
Okay, great. And thank you. I think you kind of set the stage with that last slide for some of the examples. And while there was some clarification with respect to the deadline extensions, as far as pertaining to an individual who is eligible for the subsidy in a special election, that they have only 60 days, that these, quite extended deadlines do not apply to that election. I think there's a lot of questions that still remain unclear. And, for somebody, let's say, who's eligible for an extended election period, and they actually did want retroactive coverage and they're also eligible for a subsidy, how would that work? And it's probably the exception who's going to want to go back and have retroactive coverage. But it's really not clear how that would work. So to use this example, Jordan, who was laid off in February of 2020, his COBRA election year began on March 1st of 2020. Of course, that's when the deadline suspensions, the tolling began. But normally his election period would have been April 29th of 2020. Absent those extensions, he hasn't made an election. Due to the tolling, he has until the end of April of this year to elect COBRA retroactive to March of 2020. So, it's an open question. So how do these deadline extensions interact with the ARPA election? It would seem that he'd make one election, for the subsidy period, and yet would have 60 days. We're assuming he's eligible. He was laid off. Let's assume he's not eligible for other group health coverage or Medicare. And he's still within the 18-month period, so he'd have 60 days to make an election for the subsidized coverage. But then would it be a separate election if he wanted the coverage retroactive to March of 2020? It would seem to be the case, but that's not entirely clear at this point. So I know the regulators have been asked for clarification on that by some industry groups, so hopefully we'll receive that in the near future. And then the next example follows along the same line. We have Jocelyn who experienced a reduction of hours in August of 2020, and she became eligible for COBRA on September 1st of 2020. She elected COBRA, but then stopped paying for it in February of 2021. So assume she's not, eligible for other group coverage or Medicare. She's within the elections period. She's experienced a reduction of hours. And now she'd receive the notice of a special election. So she could come back in and elect COBRA within the 60 days and receive the subsidized coverage from April to September. It appears she could also continue the coverage prospectively after the subsidy ends without any of her payments being applied retroactively to the missed payment periods. So I think that's, that's a little confusing. If a payment comes in after the subsidy ends, where would that be applied to? So I think there needs to be some clarification still on those issues. So those remain open questions. And just a few other things we're going to wrap up about the special elections before we move on to notices. Does the ARPA allow qualified beneficiaries to change coverage to another plan option? Now this is, this is kind of an unusual provision that was put in, and the answer here is yes. Employers have the option of allowing qualified beneficiaries to change coverage to another plan option. The qualified beneficiary could only choose coverage that costs the same or less than the coverage they already have. And if the employer allows it, they would have to provide notice to the beneficiary and give them 90 days from the date of the notice to make the change. This is kind of unusual provision. We know that normally, the qualified beneficiary has to be covered by the plan that covered them on the day before the qualifying event, and they're really only allowed to change coverage elections during open enrollment. They're given the same opportunities as similarly situated active employees. So this is an unusual provision, and I guess a question we'd ask is, why did ARPA include this provision? And it's not really clear. There was the original bill, I believe, was an 85%, or proposed bill was 85% subsidy, and maybe it's a carryover from that, even though they finally landed on 100% subsidy. Perhaps the thought was that if the employee changed to a lower cost option, they might be more likely to continue with that coverage after the subsidy ends. But it's not entirely clear. I haven't heard of too many employers interested in offering this option, and I would think in many cases the beneficiaries would likely not choose, if it's being fully paid for, coverage that's less expensive. But there probably are some exceptions to that. The questions that come up then: would active employees also need to be allowed to change plan options? I don't know if that's entirely clear. I mean, the options that are available to these qualified beneficiaries would have to be those that are offered to active employees. It's not entirely clear if that means that, just ones that were offered to those active, similarly situated active employees at open enrollments, or if a new election would have to be open to them. So I think that's a point that needs further clarification. And then the other question that comes up here with an insured plan is really, would the carrier agree? Because essentially the change, by the change, the insurance would be covering a qualified beneficiary for COBRA who didn't have coverage as an active employee, prior to the COBRA qualifying event, and also in a situation there's a gap in coverage. So, I think an employer is considering that. That is something they want to review with the carrier. Is the expiration of the COBRA subsidy a qualifying event to permit an individual to enroll in group health plan coverage? This is kind of a concern going forward, for those beneficiaries who elect and receive the COBRA subsidy, and then they after that, that subsidy ends, and they choose not to continue the coverage and pay for it. Would they be eligible to enroll, get another group health plan? And the answer, as far as another group health plan, is no. absent other guidance, it's not an IRS permitted qualifying event. However, if the COBRA maximum coverage period has ended, that's a different situation. And also, the question comes up, would a qualified beneficiary be entitled to a special enrollment period to enroll in exchange coverage? And the answer to this is yes. I think that's something of a change from prior regulations that happened last year, but it was actually confirmed in the DOL FAQs that were released today. So those individuals who lose coverage, maybe it's not a situation where their maximum coverage period, COBRA coverage period has ended, but they just choose not to continue the coverage and pay for it. They would have the option to, a special enrollment period to enroll in exchange coverage. And just to review some of the items that Diana have covered regarding these special elections and extensions, things to consider, if an employer does offer multiple plan options, they should consider whether they want to allow that option for the beneficiary to enroll in a different but not more costly plan option than the one they were enrolled in before the coverage was lost. Not required, but if elected, that option does need to be included in the notices. Insured plan should verify with the carrier whether that option would be permitted. The subsidy, just a general thought, is going to make it more likely that employees will elect COBRA for the subsidy period. This could result in higher claims and potentially affecting the insurance or stop loss coverage at renewal. So that's something that the employer might want to just discuss with the carrier and budget accordingly for that. And then finally, self-insured employers may also want to verify that the stop loss coverage applies to claims incurred by those receiving the COBRA subsidies or extended enrollment rights. And just something to verify there's no gap in that coverage. And that's all on this section. And Diana, I'm going to kick it back to you to discuss notices, including those new model notices we received today.
Thank you. Yeah, as Carol mentioned initially and just now, want to make sure everybody's aware that the model notices were shared earlier today. We linked them at the beginning of our presentation, and we'll summarize them in just a few slides, but would encourage folks and employers to review those notices so that they understand the content. What notice requirements apply for the subsidies and special elections? We've been fielding several questions around the notice requirements. We've had some pretty good guidance and some clarification based on the content of the notices that we received earlier today. But the plan administrator, generally that's the employer, is required to provide the subsidy eligible qualified beneficiaries with the notice of subsidy available and, if applicable, a special enrollment period notice. And this has to be done by May 31st. All qualified beneficiaries who are entitled to elect COBRA before April 1 must be notified of their new rights. And the DOL, apologize, we'll update the slide, is to issue a model notice by April 10, and they did that today. For those who become eligible during the subsidy period, so let's say somebody is involuntarily terminated from employment in May, the general COBRA election notice timing applies. And standard COBRA election notice should be updated with the content required that we'll talk about or the new model notice utilized to explain any rights under ARPA. Now, another question we receive often too is the delivery method for COBRA notices. And that is generally best practice is via first-class mail to the individual's last known address. And we'll elaborate on that in just a quick second. But I do want to point out that, and we receive this question often, not necessarily only related to COBRA, but if employers are required to use model notices. No, but it's generally advised for ease of administration and to make sure that they're compliant with the content requirements. And as I was just stating on whether or not these notices can be distributed electronically. And our answer to that is generally no, and that's because it's impracticable. And I will say, not to call me out on being, incorrect on that, the general distribution rules apply here, which do permit electronic disclosure. But the reason why this is a generally no response and that it's impracticable is because it's unlikely that an employer has email or that an individual would have computer access if they are involuntarily terminated. Now, it could be okay if we're dealing with reduction of hours. So our default is that the delivery method best practice for COBRA notices is generally that first-class mail using the participant or the individual's last known address. All right. Next question that we are receiving is what information is included in the notice? And now ARPA provided the substantive content required, and then the notices that we suggest be reviewed that were distributed today include this content. It includes the forms that are required for establishing eligibility for the subsidy. It needs to include the name, address, and telephone number of the plan administrator and any other person maintaining relevant information regarding premium assistance, a description of the extended election period, a description of the obligation of the qualified beneficiary to let the plan know when they've become eligible for other group medical coverage or Medicare, and the penalty for failing to do so. So that highlights what Beth was mentioning on several questions we've been receiving, is that there is, and we will elaborate on this in a few slides, there is an individual obligation to notify the plan, and this notice needs to tell that individual what they're obligated to do and how they do it, because if they don't do it, they could be subject to penalty. The notice should also include a description that is displayed in a prominent manner of the qualified beneficiary's right to a subsidized premium and any conditions on that entitlement to the subsidy, and a description of the qualified beneficiary's option to enroll in different coverage if the employer is choosing to permit that. So a few questions we get that is related to this topic is who is obligated to provide the notice? And again, I want to reiterate that onus falls onto the employer even when contracting with a third party or COBRA vendor. Can I reference the COBRA administrator as the contact? Probably, but I want to go over to the second bullet where it is required to have the name and the contact information for the plan administrator. That doesn't necessarily preclude that including any COBRA administration information, but you could not use a COBRA administrator's contact information in lieu of plan administrator contact information. And what is the duration of the election period? As mentioned prior, and that is 60 days. The guidance we received, I believe, I'm a little cross-eyed at this point, did specify that if an individual who receives a notice does not elect COBRA during the 60-day election period, then they forfeit their right to a COBRA subsidy. Are there any other notice requirements? And I alluded to it in the last slide, in that employers are also required to provide the notice of, oh, I lied. I thought we were talking about a different topic here. But yes, there are other employer notice requirements. Employers are required to provide notice regarding the expiration of the COBRA premium subsidy, and that this notice has to be provided between 15 and 40 days before the date the subsidies end. And so we have and the general notice that provides all the information we just discussed, and then also a notice to let folks know that the subsidies are going to end. And this has to explain that the qualified beneficiary can continue to be covered by COBRA for the remainder of the maximum COBRA coverage period, but the subsidy won't apply post September 30, 2021. The notice is not required, though, if the qualified beneficiary notified the group health plan that they are eligible for other group coverage or Medicare. And the DOL is expected to produce a model notice for the expiration of the premium subsidy by April 26, 2021. All right, so what questions do we have here? I love efficiencies just as much as the next guy. So we're often being asked, can we include this information regarding the expiration in the special election notice to avoid sending two notices? And we are saying, without any further information, the answer is no, because as you might see from the second bullet on the left-hand side, that there are certain timing parameters that the expiration notice needs to be provided within, and it wouldn't meet those parameters likely. So including a 2-for notice would not meet the between 15 and 45 days notice when the expiration notice needs to be distributed. All right, do participants have any notice obligations? And that answer, as I was alluding to in a few slides ago, is yes. A participant who becomes eligible for other group health plan coverage or Medicare, they're required to notify the plan. And that's within a certain time frame. If they do not, that individual is subject to certain monetary penalties. I do want to clarify too here, some guidance from the FAQs is that eligibility for other group health plan coverage, as it's already been stated, does include through spouses employment, okay? And then to reiterate, what if the employer becomes aware of the participant's eligibility for other coverage? Well, here we're kind of unclear what the responsibilities are without any further guidance, but we've been asked it a few times on, hey, if the employer becomes aware of the participant's eligibility for other coverage, what is the employer's responsibility? And we're just not sure what an employer is required to do in that instance. Now, and then the other question that comes along with this topic is who enforces and collects the penalty? And that is not the employer. It would be up to the DOL and the IRS to enforce the penalties provided to a participant who would willfully not provide the notice disclosure that they are eligible for other group health plan or Medicare coverage. All right, so here's a handy dandy summary chart of the model notices that we have access to as of today. And these were shared earlier this morning. So we have a model notice, a model general notice, and COBRA a contribution coverage election notice. And this applies to qualified beneficiaries who have qualifying events occurring from April 1 through September 30th. We also have our hands on the model notice that applies to the extended special election period. And that applies to qualified beneficiaries who are currently enrolled in COBRA coverage due to that involuntary termination or reduction of hours, as well as those who would be eligible for the premium if they had elected or maintained their COBRA coverage. We have a model alternative notice, and that is to be used for coverage due to state continuation through the eligible period of April 1 to September 30. And there's also a model notice of the expiration of premium assistance. So that has already been shared. And that's for use to notify those assistance eligible individuals between that 45 and 50 day period, or I'm sorry, 45 and 15 day period before their assistance expires. So just to reiterate, no later than, no sooner than 45 days prior to the expiration, no later than 15. That notice needs to be provided. And then there's also a summary of COBRA premium assistance provisions under ARPA, and that is for qualified beneficiaries who are assistance eligible, and it accompanies that general notice and COBRA contribution election notice, the extended election notice, and the alternative notice. So we have quite a few notices to review. All right, so what are some employer action items here? Number one, and to reiterate, it's not on the slide, is to review the model notices that were provided today. Number two, to be privy to the strict timelines that apply to these notice requirements. When we're dealing with COBRA, the sooner the better. Employers will need to also identify those individuals who will need to receive a notice about the new subsidy, and Carol has already mentioned this a few times. This would include anyone currently on COBRA due to involuntary termination or reduction of hours, and these individuals need to be notified of their right to the subsidy. This also includes those who could have been on COBRA, but for who could have been on COBRA for these reasons, so the involuntary termination of employment or reduction of hours, for at least 1 month during that April through September timeframe, but never elected COBRA or dropped the COBRA coverage. And this would need to be, these folks need to be notified of their new election rights by May 31st. Those whose COBRA qualifying event occurs on or after 4/1 will need to be notified of the ARPA subsidy. And that throughout this presentation, we've been reiterating that employers will need to work with any COBRA vendors applicable to determine current addresses of those eligible and to discuss the notification process. Because again, while we all often elicit the assistance of COBRA vendors, the ultimate responsibility lies with the employer. All right. So lastly, before we get into other fun topics, let's discuss how the tax credits are claimed briefly. And the premium subsidy is paid through a refundable payroll tax credit, very similar to the guidance we received under the FFCRA. Now, generally, the employer will be the one claiming this tax credit for insured and self-insured plans through the employer's quarterly tax return. And the carrier, though, will be claiming for a fully insured plan that is not subject to federal COBRA, that would be issuing state continuation coverage only. And a few nuances to that is if the premium subsidy is greater than the taxes due, the employer can apply for a refund. Employers may also apply in advance for amounts of the premium subsidies, and that the tax credit can include administrative fees. And what we usually see there is the additional 2% of the cost of COBRA. Unfortunately, at this time, we don't have more clarification on what exactly the administrative fees include outside of that 2%. And then the IRS hopefully will be providing additional guidance as to the mechanics and documentation required. And as far as who applies for the tax credit, that depends. Generally, it's the employer, but would be the carrier for those fully insured plans not subject to federal COBRA. The entire amount of premium can be claimed, as well as the administrative fees, but hopefully we'll have some more guidance on what those administrative fees include. And it is an employer, so this is a popular question or a heavy hitter, is an employer who already fully subsidizes COBRA, let's say through a severance agreement, eligible for the tax credit. And really here is there's more than meets the eye here. Likely, maybe, yes, but we would recommend discussing with counsel to really understand the nuances and requirements of that severance agreement before definitively knowing whether or not an individual, the employer would be eligible for the tax credit in that instance. So with that, what are some action items? Employment, very importantly, be blinking and in red, and that employers should discuss these obligations to pay for the coverage and access the credit with their tax advisors or an accountant or counsel, and that an employer who offers those severance plans that provide employer-paid COBRA should consult with counsel as to how the tax credit can be used and whether it can be used. An employer should be prepared to track those who took advantage of the subsidy and for how long in order to, in anticipation of filing for that tax credit. And just to be prepared, employers should be aware of a possibility of a subsidy extension beyond 9/30. We do not have a crystal ball, but it's just something to be mindful of. And some continued unanswered questions that we still have. So what exactly does involuntary termination or reduction of hours mean? We don't necessarily have all the guidance we'd like on all the situations that would rise to the level of involuntary termination. We did get a little more clarification, as Beth mentioned previously, regarding what reduction of hours means, but we're hoping to get a little bit more clarification there. Can employers who furloughed employees but allowed them to remain active on the plan now choose to terminate them and offer COBRA to take advantage of these subsidies? We don't know. There isn't guidance directly applicable to that scenario. And then this is a really big question that remains, is how exactly does ARPA's COBRA benefit interact with state continuation, in particular, those states that might have state continuation that provides 36 months of coverage. So how far back would an employer have to look if state continuation is 36 months or if it's only 6 or 9 months? We don't have clarification on that right now, unfortunately. And then will the subsidies be provided on family premiums or self premiums? So for example, if the qualified beneficiary elected family, could their spouse and dependents come back and elect self only, or is it limited? So those are some of the questions that are still leaving us hanging that we hope to have guidance on in the coming weeks. And with that, I'm going to kick it over to Carol. Actually, I should ask Beth, and I know we're running a little short on time. Before we move on out of COBRA subsidies and into FFCRA in a little recap discussion, Beth, are there any questions that we should address?
So we got a whole bunch of questions, and in the interest of time, I'm not going to go into specific questions, but I will just make the point that a lot of people asked eligibility questions for very specific kind of facts and circumstances. And I will point out that it's going to be really important, if your facts and circumstances present any kind of gray area, you're going to want to consult with legal counsel. Okay. We had a lot of questions about people who might be in severance, who the employer is paying for their severance or coverage during severance. And that kind of is a question that really is going to depend on the terms of the severance agreement. And so things like that really do need to be addressed by counsel. Other than that, I would just say, remember the regular rules for COBRA, right? Because although this is changing kind of who can come in and elect COBRA, some of the things about COBRA are not going to change. So I talked about the question earlier about, which coverage they could access if they did not have certain coverages the day before the terminating event. Things like that are going to be similar, but just kind of keep that in mind as you are, figuring out who is going to be eligible for this coverage.
Thank you.
Mm-hmm.
Well, thank you both. And Diane, that was a great overview of the notices, especially the new notices that are now available, the models. So just a great overall summary of that section. I think that's important. We do want to switch gears a little here and just discuss the FFCRA leave briefly. Unfortunately, we haven't received any implementation guidance regarding this. Hopefully we'll receive that from the DOL soon. Often it's in the form of Q&As on their website. But let's just review what we know now. And the background, of course, is that the FFCRA leave, the original leave, it required employers, those with less than 500 employees, to provide paid emergency sick leave and expanded FMLA that was through the end of December of 2020. Employers could claim a tax credit for the leave provided. And there were originally the emergency paid sick leave up to 80 hours could be taken by employees for specific reasons, diagnosis of COVID-19, under quarantine, under an official order or recommendation, providing care to somebody COVID-19 diagnosed or seeking a diagnosis or care for symptoms, caring for experiencing similar conditions. So there were a number of reasons where you could take the emergency paid sick leave. That was under the original provision, and also up to 12 weeks of the expanded FMLA, which could be taken by employees with at least 30 days of service if they needed to care for their son or daughter whose school or child care place was unavailable due to COVID-19. So there's just one reason for the expanded FMLA. Of course, these provisions expired. And if we go to the next slide, we know after December 31st, the leave was no longer mandatory, but the Consolidated Appropriations Act provided a voluntary extension through the end of March of this year. So covered employers could voluntarily offer the leave and also receive the tax credits. Now, under ARPA, there's an additional 6-month extension. So employers that elect to continue providing the leave can continue to claim the tax credit through the end of September. It's completely voluntary, but there are some changes to the provisions from the original version. So we just want to discuss those and some of the questions that we're receiving and give you our thoughts on them, although we don't have definitive answers on many of these at this point. So I think one of the questions that we're receiving are, well, when we can answer, are employers required to continue providing the FFCR leave? Clearly, no. Can an employer offer one type of leave and not the other? Unclear. It would seem to be that an employer could. It's voluntary at this point. So could you offer, emergency paid sick leave and not the expanded FMLA? We would think so, but we couldn't say that definitively. How did ARPA modify the FFCRA leave? And one of the main reasons was that it expanded some of the reasons that the emergency paid sick leave could be taken. It now includes time waiting for COVID-19 test results, time to receive a vaccine, or recover from an illness related to the vaccine. I guess if you had some type of a reaction to it. It also grants an additional 80 hours of emergency paid sick leave. Also, employees can now use the expanded FMLA for any of the reasons that the paid sick leave could be used. So, as we just discussed, originally the emergency paid sick leave could only be used. The expanded FMLA could only be used for childcare reasons. So now, an employer could use that for any of the original reasons that they could use the paid sick leave, but also for these new reasons, including, waiting for COVID-19 test results or getting the vaccine. So we've got expanded reasons to use the expanded FMLA. And additionally, the first 10 days of that expanded FMLA can now be paid, and the maximum leave amount is increased to $12,000 in the aggregate to correspond with that change, allowing the first 10 days to be paid. So the questions that we're receiving here, can an employer offer the FFCRA leave if they chose not to do so through March? That would appear to be the case. It's completely voluntary, and in some ways it appears to reset as of April 1st. So we believe an employer could choose to do that. Did ARPA provide additional emergency expanded FMLA leave to those who might have exhausted the prior expanded FMLA leave? And this is kind of an interesting question we don't know the answer to. We know that the emergency paid sick leave, there appears to be a grant of an additional 80 hours as of April 1st. Originally, if you recall, the expanded FMLA was coordinated with conventional FMLA, and an employee had a maximum of 12 weeks in whatever period the employer was tracking, and then it was exhausted. So we don't know if that is still the case where it's coordinated, or if there's some type of a new allotment. So that's an area where we need clarification. Can an employer use the FFCRA leave to satisfy state leave requirements, the paid vaccine leave time? This question has come up where states, including states such as New York, are requiring employers to give paid time off to receive the vaccine. I believe it's at least 4 hours per shot. And the New York law is worded so that it's in addition to any other leave that the employee is otherwise entitled to receive. So could the employer use the FFCRA leave and get the tax credit then if they have to provide this paid leave? And that's really unclear at this point, and that's not going to be something the DOL clarifies for us. It's going to be really each state will have to have the state authorities clarify if the FFCRA leave could be used for that purpose. How did ARPA modify FFCRA leave? I guess continuing on here, one other thing that's new is the ARPA applies a non-discrimination requirement to FFCRA leave. We didn't have that previously. And it states that employers cannot claim a tax credit on the leave wages paid for a quarter if the employer discriminates in favor of highly compensated employees, full-time employees, or employees on the basis of tenure when providing leave. And the non-discrimination requirement appears to apply separately for the paid sick leave and expanded FMLA. So an employer should be aware if offering to only certain classifications of employees. So the questions we're receiving here, and we do need clarification because we really don't have it on really how these non-discrimination requirements are going to apply. But we do receive the question of, does the emergency paid sick leave necessarily need to be reset for all full-time employees to provide the additional 80 hours? Some employers are saying, well, if they already used some, let's say in the first quarter of 2021, could they just be entitled to the difference rather than having this reset as of April 1st that ARPA seems to imply? And we don't know, but if this non-discrimination requirement is setting in April 1st, it may be better that everybody has the same amount of leave then, as of that date, rather than having certain people who used it prior and different allotments. I mean, you could run into trouble, I would think, with these non-discrimination requirements that way. Can the leave be offered to just certain classes of employees? Again, we don't know. We know other non-discrimination requirements when we're talking about testing for plans, do allow for that, for bona fide classifications of employees, for leave to be offered along those lines. But then the non-discrimination testing requirements would kick in. So we're not sure. We think we need to have more information regarding these non-discrimination requirements before we can answer that question. I know we're running out of time here, so employer action items need to determine as voluntary. Do you wish to extend the FFCRA leave through the end of September? Employers electing to continue leave should be aware of the non-discrimination requirements. We don't have specific notice requirements or models or posters yet, but obviously notice should be provided to employees including the new qualifying reasons for the leave, and the employer should be prepared to continue maintaining supporting documentation, to be able to track the leave and file for the tax credits. And we hope that the DOL and the IRS for the tax credits will provide clarification on those outstanding issues soon. And Diane, I'll hand it back over to you. I know we have a few minutes left on the DCAP exclusion increase.
Okay, thanks. And for the sake of time, I'm going to be pretty brief on the DCAPs, although we are still receiving a lot of questions on this. And the ARPA does increase a participant's DCAP reimbursement amount for calendar year 2021 only. The increase, generally speaking, the amount that can be excluded from income is $5,000 unless the employee is married, filed separately, then it's $2,500. And ARPA provided an increase to $10,500 or $5,250 if the employee is married, filing separately. For taxable years beginning after December 31, 2020 and before January 1, 2022, so that would be the calendar year 2021. What this means is that amounts over $5,000 that are reimbursed through a DCAP in 2021, let's say if an employer should choose to do one of the extended carryovers or grace period provisions provided by the DAA, that is not treated as taxable income for participants. And so the questions we're receiving around this is does that mean that participants can contribute up to $10,500 to their DCAP due to the increase in the DCAP exclusion? It seems to imply that an employer can amend its plan to permit up to $10,500 in contributions. However, if an employer chooses to do that and also is permitting a carryover or grace period provision amounts, keep in mind any amounts used over that $10,500 would be subject to taxation in the 2021 year. And so we have several unanswered questions on this. Does an employer have to allow election in excess of $5,000? Likely no, but we're not sure. This is usually a matter of plan design. What does this mean for the 2022 plan year? As of now, for 2022, the exclusion will go back to $5,000, and participants will need to plan, especially if an employer is permitting a carryover or there's a carryover grace period or for non-calendar year plans. And keep in mind, non-discrimination testing still applies. So for those employers who have already tested their plans or choose to increase the elections, that you may want to retest the plan because there could be a negative impact. If you choose to increase the limit over $5,000, revisit your plan documents. They likely need to be amended, and that employers should work with their vendors to implement any changes. And with that, I'll let Carol conclude, and we'll hand it back over to Beth. Carol, you might be on mute.
Thanks, Diane. I'll close it out quickly here in the interest of time. The law, of course, is new. ARPA is new. We received some guidance today. We expect more in the coming weeks. It's important now with the COBRA subsidies to review your employment records, determine who's eligible, and work with your vendors to ensure the qualified beneficiaries are notified timely. The ultimate responsibility lies with the employer. Eligible employers should determine if they wish to offer or continue offering voluntary FFCRA leave and take advantage of the available tax credits. Employers that sponsor DCAP should determine if any elective plan changes will be made as a result of some of the temporary relief measures and increased exclusion amounts. And of course, we're monitoring developments closely, and we'll update our resources as additional information is released. And we do expect more in the near future, so please register for our next ARPA webinar a week from today on April 14th for the latest guidance. And that's all. I'll close it out then and turn it back over to you, Leanne.
Thanks, Carol. And real quick, Beth, is there anything else you want to add, or are you ready for us to close out?
No, I think we're ready to close out. As Carol mentioned, look out for upcoming, resources and such. We did actually create an FAQ document on the ARPA that we will be updating, obviously, with today's guidance. And so look out for that and ask your advisor for those updated resources. So it's all you, Leanne.
Thanks, Beth. And thank you also, of course, to Diane and Carol for sharing your valuable time and your expertise with us today. Thank you also to our entire benefits compliance team for moderating the Q&A. As a quick reminder, our session next week has also been extended to 1.5 hours to ensure that we cover all of the material. And today's presentation was recorded and will be emailed out tomorrow. The recording and slide deck from this webinar will be posted to the nfb.com latest insights page under the webinars/training section. That concludes our webinar for today. Thank you all so much for joining us, and have a great day.